I'm seeing a lot of questions about the timelines and the status of the appeal. So let's break it down. First, and as a preliminary matter, yes, the appeal is going forward. There have been a lot of questions about the bond amount that Amber Heard was required to post in order to be able to appeal. And this stemmed, I believe, from some confusion, some misunderstanding over something that Judge Azcarate said during the hearing when the judgment was presented. She made an observation that there would be a suspension bond and that the amount of the suspension bond would be the $10.3 million that was the judgment, plus the one year's interest, basically. And so a lot of people understood that to mean that the suspension bond was a requirement of the appeal. But the statute for this makes it very clear that it's not. It is simply something the parties have the option to use if they want to, but it's not a requirement. The reason why they would want to use it is because what it does is it prevents the other side from being able to collect the judgment while the appeal is ongoing. So typical collection tools can include things like debtors' examinations, garnishments, writs of attachment, writs of execution, basically seizing your property, calling you into court to testify under oath about your assets and where they are and things like that. So if you don't want to go through those things and you also, don't want to pay your judgment, then this suspension bond is the way to keep that at bay until the time that the appeal is resolved, with the benefit that, hey, then if you win your appeal, you don't have to go try to claw back, whatever your opponent has been able to get out of you. But it also gives protection to the person who won in court, because if they win the appeal, their judgment is then able to be satisfied out of that bond. So then they don't have to go through the expense and difficulty, hassle of the collection process themselves. Those requirements to appeal in Virginia are very simple. They have to file a notice of appeal within 30 days of the judgment being entered, and they have to post a $500 bond that essentially just covers costs. That's the appeal bond. So both of them have met this requirement. The judgment was filed on June 24th. And Amber's notice of appeal was received in the Court of Appeals on July 21st, so well within the 30-day time limit. Johnny's was filed the following day on July the 22nd, so he's well within that 30 days as well. Where we're at this point now is what's called the perfection stage of the appeal. And essentially what that means is that everything the Court of Appeals is going to need to read and review and look at in order to decide the case is being compiled and sent up to them. So Virginia has another rule as well about this that describes what the appellate record consists of. And it's basically the exhibits, any depositions that are designated, filings, things that are in the possession of the court, the circuit court, that will be relevant to the issues that are anticipated to be presented on appeal. So then the clerk under this rule has 3 months from the entry of the judgment in order to transmit that record up to the Court of Appeals. So just back of the envelope math here, judgment entered June 24th. That's taking us till approximately September 24th is the deadline for the Fairfax County Clerk to send that record up to the Court of Appeals. Now, there's a very important proviso here, which is that if they don't get it done within that time, that is not going to cause the appeal to be dismissed. The rules make that perfectly clear. So it does seem to contemplate that while, yes, this is a deadline and it's even expressed in this fairly mandatory language, there's not necessarily going to be a serious consequence if that didn't happen. And in this particular case, we know that the record is extremely voluminous. I mean, just the depositions alone that Elaine has filed could probably fill a dump truck. So it's probably a little bit larger than the normal case. And so for that reason, there may be some flexibility where some of these deadlines are concerned. So then we'll find out what they are actually going to argue in this appeal when they file their briefs. And the briefs do not become due until 40 days after that record is filed in the Court of Appeals. So doing our back of the envelope math again, if the Fairfax County Clerk takes the full 3 months, files the record on September the 24th, then we are looking at a Halloween deadline for the briefs to be filed. Now, I don't know the culture of this particular court, and that is an important thing. There is such a thing as being a hometown lawyer, right? And just the advantages that you get from knowing what is normal in this particular setting. But I can tell you in my experience in appeals, certainly in Washington, and just from conversations that I've had with colleagues all over the country, appeal deadlines do tend to be extremely flexible, particularly in situations like these, where, as we've already pointed out, there is a lot to be going through. It's a big volume case. It was a 6-week trial. That in and of itself is a little bit unusual. So it would not surprise me at all to see if these deadlines are extended. The rule does provide for and anticipate motions for extension of time to file briefs. Very much not uncommon for attorneys to do, even frankly with normal size cases. You get busy, you have multiple things that you're trying to juggle, and the appeals courts tend to be more generous about giving extensions than, for example, your client who is sitting in jail and wants his bail hearing yesterday. So appeal deadlines can often be flexible. I don't know if that will be the case here, but it wouldn't surprise me. Another factor that would go into that as well is the newness of Amber Heard's appeal team. Now, granted, this is not a justification in and of itself to warrant taking all the time you want to go read through everything, think it over, figure it out. But it would be grounds for likely some type of professional accommodation that I think we can expect Ben Chew and Johnny Depp's team as a whole would accommodate. That is just the type of lawyers that they are. They recognize, yeah, these guys are new. Yeah, there's a lot to go through. Fine, they can have, a little bit more time. So we'll see, but that's where things stand as of right now. The appeal process is a slow one. This is something that I'm pretty accustomed to, but it's a very different pace than the trial pace where things are happening very quickly and you have short turnaround times. Because the appeal is a review process, it's just looking over what's already happened. It's not taking in new evidence. It's not relitigating things. It's just making sure there weren't any mistakes in that trial process. So there's no real rush. The judgment is presumed to be valid, presumed to be binding. It's rare that they get overturned. So there isn't an assumption that, oh, we need to hurry things in case, there's something that needs to be set right or something that needs to be fixed. The assumption is it did go the way that it was supposed to. And so all we're going to do now is just make sure that there wasn't some very substantial, very prejudicial error that requires essentially the process to be undone and redone. I will, of course, be keeping up on what happens in the appeal, following the process very closely. So if you are interested in staying updated, please stick around and I will keep you in the loop.